Despite what the government-run schools have been teaching most people for a long, long time, it's the Constitution that's supreme, not just merely whatever laws they decide to pass. And if we're listening to the founders, we have to also acknowledge that government doesn't have the final say over the extent of its own powers. Anything outside the Constitution to the founders was considered a usurpation of power, a theft of power. And from the beginning of the revolution all the way through ratification of the Constitution and even years after that as well, they had a word for this: void. It's void as soon as they try to pass it. So today I've got a bunch of examples to explain this, plus a little bit about who has the final say over the extent of powers under the Constitution. But first of all, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, June 5th, 2024. Thank you so much for being here, whether this is your first episode or you've been here for every single one since day one. So let's start talking about this word void. I've once, at times in the past, I've referred to it as one of the favorite words of the founders. Hear from James Otis Jr. in his thunderous speech for hours against the writs of assistance in February of 1761, which years later, John Adams said this was the beginning of the American Revolution. If we think of the real American Revolution as the radical change in the viewpoints of the people from just being mere subjects to a sovereign power that could do whatever it wants, to a view that sovereignty was somewhere else. It wasn't with government. Final say, power flows from the people. So this is a radical change before the shots fired, the shot heard around the world at Lexington and Concord. And right at the beginning of that American Revolution, what Adams said, then and there, the child independence was born. James Otis Jr. made a very important point against the writs of assistance. He said, an act against the Constitution is void. Now, of course, in this situation, they're talking about the unwritten British system, the unwritten British Constitution. And this is part of the motivation why they wanted written constitutions in these United States, because they wanted the rules spelled out. You didn't have to just kind of rely on government to determine the extent of its own powers. So an act against the Constitution is void, said James Otis Jr. We see this type of viewpoint replicated over and over and over from that point on. I've got a couple of highlights here, for example, from the Boston town meeting. This is a memorial to the House, the representatives in Massachusetts in 1764. They say the question is not upon the general power or right of the Parliament. So they're saying, look, the controversy here isn't that Parliament has power. It's the extent of that power. But whether it is not circumscribed with some equitable and reasonable bounds. It is hoped it will not be considered as a new doctrine that even the authority of the Parliament of Great Britain is circumscribed by certain bounds, which, if exceeded, their acts become those of mere power without right and consequently void. So the viewpoint early on in the American Revolution, and we make the case many times that this is really the underlying principle behind the American Revolution, that there are limits on power and that acts that go beyond that power are void. But it's up to the people to do something about that as well. Here's Patrick Henry in his great resolves against the Stamp Act in May of 1765, just merely 29 years old, only 11 days in office, and he's thundering forward. Resolve that the General Assembly of this colony, together with His Majesty or his substitutes, have in their representative capacity the only exclusive right and power to lay taxes and imposts upon the inhabitants of this colony, and that every attempt to vest such power in any other person or persons whatever than the General Assembly aforesaid is illegal, unconstitutional, and unjust, and have a manifest tendency to destroy British as well as American liberty. So it's not the exact same verbiage as James Otis Jr. a few years earlier, where he says an act against the Constitution is void. So he's pointing out that, look, this is an unconstitutional act. And Patrick Henry, one of the people that we would say is one of the original supporters of the principles behind what became the 10th Amendment many years later, that of delegated and reserved powers, he's taking the position that governments at different levels have different authorities. So Parliament has certain powers, but the local stuff is only handled by the General Assembly of the People of Virginia. And anything beyond that is automatically unconstitutional and illegal. It's not about waiting for the government who violated the rules, violated the Constitution, to decide that, we made a mistake. Here's Samuel Adams writing as Candidus in the Boston Gazette in 1772. He said, "If then, according to Lord Coke, Magna Charta is declaratory on the principal grounds of the fundamental laws and liberties of the people, and Vattel is right in his opinion that the supreme legislative cannot change the Constitution." So again, if you have a set of rules, then anything going beyond that limit is unconstitutional and illegal. It is void. And any attempt to do so is an attempt to just change the rules on a whim. This is arbitrary power, the definition of what the revolutionaries considered a tyranny. Adams continued, "I think it follows, whether Lord Coke has expressly asserted or not, that an act of Parliament made against Magna Carta in violation of its essential parts is void." Even Alexander Hamilton used a very similar take here in The Farmer Refuted in 1775, back when he was, on the good guy's side. He said, "In short, when human laws contradict or discountenance the means which are necessary to preserve the essential rights of any society, they defeat the proper end of all laws and so become null and void." The guy who, after ratification, was, and probably before Deering as well, but even though he didn't sound like it to most people, here he is using a nullification term. The guy who wanted the biggest government, or set the foundation for the biggest government in history. Now, we can see these underlying principles brought forth to the Constitution instead of having unlimited powers. Now, there were some people at the Philadelphia Convention, Alexander Hamilton, for one, wanted totally unlimited powers. He just wanted to replicate the British system, the one that he opposed when he was a much younger man in 1770, 1774, 1775, when he was really radical in some of his takes. Now he wanted unlimited power in all cases whatsoever over the states. In fact, he pointed out to the Philadelphia Convention that he wanted to get rid of the states, but he was concerned that the people weren't ready for that. So, we'll have to do what we can do. Now, even James Madison, who I'm going to cite in this as well, he also proposed, along with Edmund Randolph and a few others, something called the Virginia Plan, which called for unlimited power in all cases whatsoever. And it's fascinating to think about that phrase, and I don't want to get too distracted by it, but this was one of the reasons that they were saying that they were fighting back. Unlimited power in all cases whatsoever. The exact same phrase was in the British Declaratory Act of 1766. But anyways, so there were proposals to give the federal government totally unlimited power. And then there were other proposals to have it much more decentralized, basically holding on to something closer to the Articles of Confederation. And the Supremacy Clause wasn't about giving them unlimited supremacy in every situation. It was considered the moderate middle ground, where they gave the federal government supremacy only in specific situations. In fact, it's not really a lot. They went with this: the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So the short version, the TLDR, is the Constitution is supreme, and laws made in pursuance of the Constitution are supreme. Nothing else. And if we understand that, as James Madison told us in Federalist 45, the powers delegated to the federal government are few and defined, that means federal supremacy is actually quite limited. St. George Tucker described it as well. He said that a law limited to such objects as may be authorized by the Constitution would, under the true construction of this clause, be the supreme law of the land, but a law not limited to those objects or not made pursuant to the Constitution would not be the supreme law of the land, but an act of usurpation and consequently void. Now, I know people will have questions like, okay, yeah, in theory it's void, but what do we do about it? I'm not really going to get too detailed into that on this episode because I've got many others that cover that as well. And I'll see if I can get one link to that in the show notes as well, a recommendation on how to enforce the Constitution. I've done one just this year, the real enforcement mechanism according to the founders, but I'll get a little hint about that here at the end as well. Here's Governor Samuel Johnston with a very similar take about the Supremacy Clause and anything beyond it being a usurpation and void in the North Carolina Ratifying Convention. He said, every law consistent with the Constitution will have been made in pursuance of the powers granted by it. Every usurpation or law repugnant to it cannot have been made in pursuance of its powers. The latter will be nugatory and void. Again, the whole idea of the American Revolution is that the far-off government only had a certain number of powers, and going beyond that really destroyed the liberties of the people, and it was crossing a line in the sand. It was trying to exercise arbitrary powers that were void in principle, and so that's why they had to resist it. I've covered the Supremacy Clause in much more detail in a number of episodes, most recently just January of this year, Constitution 101 Supremacy Clause. And I think that will be a good one for you to check out as well. If you want to get details on the original legal meaning of the clause, I will include that in the show notes. Actually, Alan Mosley will get the blog post organized for that, and I will get it published a couple hours after this live stream is done over at 10thamendmentcenter.com/path to liberty. There we include all the different platforms we're on. Of course, we live stream over at YouTube and Facebook and X and LinkedIn and Twitch and elsewhere. We also live stream at rumble.com and odyssey.com. Hello over to Jared and Dennis and a few others over on Rumble. I appreciate you being there. I know I've got to get back to some comments from Marginal over on Odyssey. And I want to say hi to everyone out in the live chat, Facebook, YouTube, and elsewhere. There's John and Howard, Haji, Techno Trucker Dude, Chris Green, Kirk, Melody, and everyone else. Again, I appreciate you guys being here. We'll get a blog post published for this episode so you can follow along. You can read all the original source documents, check out these other episodes in context, and learn more on your own time. That's 10thamendmentcenter.com/path to liberty, where we publish everything and you can follow us. So we're talking about that word void. Here, for example, Roger Sherman describing this structure under the Constitution in December of 1787. All acts of the Congress not warranted by the Constitution would be void. This should be obvious. But the important point is it's not up to the government itself to determine when the government didn't follow the rules or broke the rules given to it. Because when you do that, you're just encouraging them to come up with reasons to say they didn't. And then government power will always grow. And that's basically where we're at today. Here's Oliver Ellsworth, the third Chief Justice of the United States. He said, if they make a law which the Constitution does not authorize, it is void. And again, Alexander Hamilton hammered this home in Federalist number 78. He said, there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. And I know we're hearing the same thing over and over and over again, but we have to point out that every single time, not just the big stuff, it's every act of a delegated authority contrary to the tenor of the commission under which it is exercised is void. He said, therefore, no legislative act contrary to the Constitution can be valid. And if it's invalid, if it's void, what are you supposed to do in order to treat it that way? That's an interesting question as well. Thomas Jefferson gets into this. This is, again, an affirmation that the Constitution is supreme and not just any federal act that they decide to pass. And that's how he put it in his draft for the Kentucky Resolutions of 1798 against the hated Alien Sedition Acts of the Adams administration. He said, the several states composing the United States of America are not united on the principle of unlimited submission to their general government. In other words, just because the government does something and that same government decides, well, this is okay for us to do, that doesn't mean that it is constitutional. And Jefferson's saying is the several states, that is the people of the several states, as Madison makes clear as well, they did not unite in this system in order to just bend a knee to unlimited power. That's the whole point. He said they constituted a general government for special purposes. That's a reiteration of what Madison said some years earlier. In Federalist 45, again, the powers delegated by the proposed Constitution to the general government would be few and defined. Those reserved to the states. The people of the several states are numerous and indefinite. He said, again, Jefferson, they constituted a general government for special purposes. It's all delegated, spelled out there. Delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government. And of course, he continues, and so whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Here in 1798, we get the same message from Thomas Jefferson as we would get from his archenemy at that time, Alexander Hamilton, as we get at the very beginning of the American Revolution in 1761, acts that go beyond the limits of the power given to the government by the people, the sovereign people of the several states under the Constitution, is unauthoritative, void, and of no force. And Hamilton explains why. And again, he sounded like one of the good guys before he flipped the switch, and I think that was his plan all along, was just to be a scammer. But this mentality is what the people of New York decided to ratify the Constitution under this view. He said to deny this would be to affirm that the deputy is greater than his principal. So Hamilton's recognizing that power flows from the people of the states to the general government. And if the general government gets the final say rather than the people who created the entire system in the first place, that would mean that the deputy, the agent of the people, has more power than the people themselves. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. Damn, where did this Hamilton go? It's too bad. That men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. So the idea that government has final say over itself is absurd. And so, of course, the question that I keep hinting at is, what do most people have as a question? Who decides? For Thomas Jefferson, it's certainly not the federal government. They do not get the final say over themselves. He said the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers. So as long as you go to government and you expect the government to follow the rules given to the government, and when the government breaks the rules given to the government, you ask the government to stop doing what the government was never supposed to do in the first place, you shouldn't be surprised when government power grows and grows and grows and grows, no matter which team is in charge. And that's the situation we've been in for decades. Rather than keeping the government in check, most people beg the government to keep itself in check. And so that's why we live under the largest government in history. I would say that is one of the primary reasons. I'm certain there's underlying issues as well, like lack of education about these things, of course. It's hard to point our finger at the exact cause of everything, of course, the Federal Reserve. But as long as people are convinced that all they have to do is find the right people to get in power or beg Supreme Court justices, basically, all these things are not the exercise of rights that make a free people. It's a population on its knees begging for permission. So Jefferson is telling us this is giving them unlimited power. So for James Madison, he talks about who decides in the last resort. So if there's a conflict over what the federal government is doing, someone has to make the final say on this. And again, James Madison, the so-called father of the Constitution, is also telling us the federal government does not have final say over itself. Here he is in his report of 1800, which is clarifying the Virginia resolutions of 1798, also against the hated Alien and Sedition Acts of that year. He said the Constitution of the United States was formed by the sanction of the states, given by each in its sovereign capacity. And then also in this document, Madison explains in detail that, yes, there are a number of definitions that you could use for the word states in this situation. For example, state governments, a geographic area. But he said in this situation, it means, quote, the people composing those political societies in their highest sovereign capacity. So the people of the several states hold their highest sovereign capacity, that is, final authority, under the constitutional system. And Madison here, again, explains what happens when you have a conflict or a question over powers delegated to the federal government or something the federal government is trying to do under the Constitution. He said the states then, again, the people of the several states in their highest sovereign capacity, the states then being the parties to the constitutional compact, and in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact made by them be violated. Now, this is very much the same message that we get from the big government crook Alexander Hamilton when he was telling the truth back in Federalist 1778. To deny this power would be to affirm that the deputy is greater than the principal, that the servant is above his master, and that the representatives of the people are superior to the people themselves. And that's how Madison is saying the final authority is the people of the several states because they're the ones that created the compact. And Thomas Jefferson said that without this setup, without this structure, the people of the states would then be under unlimited power, which is exactly what they rejected in the American Revolution. This is something that they referred to as an elective despotism. Thomas Paine called something like that. Jefferson did as well. Richard Henry Lee. We did not fight the British to get some big, strong government or get elective despotism. Jefferson said without this right, they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them. So if someone else is judging the extent of powers under the Constitution for the people who created the Constitution, then you're under their power. It is absolute and unlimited. And here's George Nicholas in the Virginia Ratifying Convention, another strong Federalist, telling the people of Virginia that, look, we have the final say over these types of things. He asked the question, who is to determine the extent of such powers? He said, I say the same power which in all well-regulated communities determines the extent of legislative powers. Oh, he starts out with this. If they exceed these powers, the judiciary will declare it void. And if not, the people will have a right to declare it void. So again, the final authority, the final say. I mean, of course, what Nicholas is saying, he's taking a little bit less aggressive of an approach. He's saying, look, the first thing you do is you go to the judges, ask them to strike it down or to declare it, in their opinion, void. But ultimately, the final say comes from the people of the several states. And if the people declare it void, what do? Hamilton told us in Federalist number 33, when they are acts of usurpation, you have to treat them as such. Well, I hope you guys found this interesting. I hope it was educational. More important than anything, I hope you learned something, and I hope this made you think a little bit. If you want to help us reach and teach more people about these essential foundational principles, we've got our 18-year anniversary, I think it is, coming up later this month. And if you want to help us kick off the next 18 years in support of the Constitution and liberty, whether the government likes it or not, they absolutely do not, you can join us for as little as $2 a month over at 10thamendmentcenter.com/members. Again, 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. I'd be extremely grateful for any consideration you can give to joining us as a member today. Again, we'll have the blog post published for this in a couple of hours over at 10thamendmentcenter.com/path-to-liberty. Make sure to follow us there. You can also smash the like button, leave a review on Apple Podcasts, comments in the archive. All these things can help trigger the algorithm and tell the platforms to show us to more people. Again, I really appreciate you being here. Hope you enjoyed the episode and hope to see you next time here on the Path to Liberty.